The man accused of trying to assassinate President Trump, as prosecutors have laid out, was surprisingly calm in his first court appearance today. And I say surprising because Tomas Allen is facing now a possible life sentence for Saturday night's alleged attack on the White House Correspondents Dinner. Today, in a D.C. federal court, prosecutors revealed again these three charges against him: transportation of a firearm and ammunition over state lines with the intent to commit a felony, discharge of a firearm during a crime of violence, and attempted assassination of the President of the United States. We put out the potential penalties there. The last charge carries that possible penalty of life behind bars. Now, despite that, Allen, who did not enter a plea, was apparently composed as the judge questioned him, even as prosecutors unveiled a harrowing affidavit outlining Allen's alleged crimes. According to that affidavit, Allen traveled from his home in Torrance, California to Washington by way of train with the alleged intent of political assassination. He was allegedly armed with a pump-action shotgun, a handgun, 3 knives, and once at the gala, prosecutors claim he fired that shotgun a single time before being subdued by Secret Service. And again, one Secret Service agent was shot in the chest. Good news, thankfully, he was wearing that body armor, though it is still unclear if it was Allen and not, another member of Secret Service who actually shot that agent. But the affidavit also references a roughly 1,000-word manifesto allegedly written by Allen, which, by the way, prosecutors say he sent just minutes before the attack. That is key from a legal point of view. We'll talk about that. And in it, Allen allegedly spells out the motive here, saying in part, onto why I did any of this: I am a citizen of the United States of America. What my representatives do reflects on me, and I am no longer willing to permit a pedophile, rapist, and traitor to coat my hands with his crimes. Those are his alleged words. And prosecutors claim they want to keep Allen in jail. A detention hearing is set for Thursday. And at a presser after court wrapped up, Jeanine Pirro, again, the U.S. Attorney for the District of Columbia, made it clear that the case against Allen was just beginning.
Those charges are only 3 charges that are in the complaint that has been presented in federal district court about an hour ago. There will be additional charges as this investigation continues to unfold.
Now, all this might come as a shock to those who knew Allen. He was a graduate of Caltech, earning a bachelor's in mechanical engineering. He worked part-time as a teacher and tutor, even winning Teacher of the Month in 2024. His public defender also noted he has no prior criminal record. But with the full force of the federal government stacked against him, Allen is going to face an uphill climb at his preliminary hearing May 11th. That's where prosecutors have to establish there's sufficient evidence for the case to move forward. It's a low bar to prove. So joining me now for a closer look at the legal picture is legendary trial attorney, host of the podcast Reasonable Doubt and Two Angry Men. Love having Mark Geragos on. Mark, so good to see you. I want to start right now with the attempted assassination charge, because we can always say proving intent can be tough. Here, though, the allegations, the manifesto, the timing of when it was sent, so close in time to this alleged incident, and the direction where he is accused of going armed, wouldn't that it seems to support that. What holes do you potentially see in that top charge?
Well, I'll tell you, if I had a nickel for every time a prosecutor had argued premeditation or intent could be formed in the split second, here you've got, if you're a prosecutor, the idea that somebody has written a very coherent manifesto is what they're calling it, but I would call it admissions and confessions in a premeditated kind of blueprint, and sent it minutes before they took the action. It's a real problem for the defense in this case. And the other real problem for the defense in this case, at first blush when this was reported, this gentleman did not fit the type, if there is a type, and profilers will tell you that there are types, of somebody who would do this or commit this act or be the person you would suspect. And normally you would look for all the indicia or badges of a mental health issue. Absent, and I don't mean to be a smartass about this, but absent TDS, a Trump derangement syndrome, which,
that's not a legal defense, though. I've never heard that as a legal defense.
It's exactly, I said, and I don't mean it as a smartass, but somebody is going to, as they do the kind of investigation into this and the building a defense and have him examined by mental health professionals, are going to have to explain and see if there is a plausible basis for at some point him kind of crossing over into mental illness, because otherwise, if you don't...
It'll be a challenge, because look, even him allegedly running through the security perimeter would suggest, I know I'm about to break the law. I know what I'm doing is illegal.
Well, by the way, part of the things that, tough facts, how about the fact that I'm carrying buckshot so that I can kind of target the people I want to target and not hit
That's
others?
A good point. That's interesting.
That's
really a good point.
Yeah, there are some really, really bad facts in this case.
When they talk about potential additional charges, what additional charges, I don't know, both on a federal, maybe state level, or could we be looking at here?
Well, the District of Columbia has this kind of unique setup, and even though this is set for a preliminary hearing, I would expect that they're going to go by way of an indictment. Most times that's what's going to happen. And if they do indict, I would expect a flurry of charges that would include others that are there. You can stack up counts, and prosecutors love to do this in terms of anybody who is in the general vicinity could be another count, so to speak. And then it also depends, they're going to probably, and are probably already working on any kind of ballistics evidence or evidence on who actually fired the shot that hit the Secret Service agent, because then there's going to be a separate legal theory that's going to be utilized for that if it was not his bullet.
I want to jump on something that Katie said in her show, and it's the idea of, this is very different, but I have to ask this question now in light of where we are, the Luigi Mangione effect. Is there a possibility that in today's political climate, it may be difficult to find a fair and impartial jury, which he's entitled to, 100% he's entitled to, but because of the nature of this incident and the potential nature of the alleged victim in this case, we're talking about the President of the United States, I don't know if it'll be a challenge or not, that people might find some sort of sympathy with what this guy's accused of doing. Then again, look at the Ryan Ruth case out in Florida. I don't think it was a problem there.
No, and I think what people have to understand is, absent very unusual circumstances, when jurors are sworn in, jurors take their duties very, very seriously. Now, mind you, Judge Jeanine has had problems getting grand juries to indict in the District of Columbia on this particular DOJ-related prosecutions. I don't think she's going to have that, that issue
different
here.
cases.
Yeah, I really don't.
Yeah, much different cases. Mark Geragos, talked to you for an hour. Thank you so much. Always appreciate you taking the time.
Thank you.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.